Hi everybody, my name's Matt Dana and I'm here today with my partner Trevor Whiting.
Hey Matt.
And we operate the Dana Whiting Law Firm, hence the name Matt Dana and Trevor Whiting. Works pretty well. So today, Trevor, we want to talk about some high-end estate planning for our potential clients. And as we know, what's really going to be important leading up into these next couple of years? What's kind of on the agenda?
Yeah, the big issue that we're dealing with these days is similar to what we've dealt with in prior years in 2012, and then we dealt with it again in 2020 and 2021, but it's that the potential for the estate tax exemption to be reduced. And so an increase in estate or death taxes, and we want to help clients prepare for that possibility, which is scheduled to happen in 2026. And so we've got the rest of 2024 and through the end of 2025 to do some planning to.
What is that current exemption right now?
The current exemption is $13.61 million per person. So a married couple can protect about $27 million of assets. But the issue is that any assets above that amount are going to be subject to a 40% federal estate tax.
Yeah.
And we want to help them protect against that.
So the estate tax really hasn't been an issue for most people the last few years because this exemption's so high. What's that exemption going to look like January 1st of 2026?
Yeah, it's historically high right now, but it's scheduled to be cut in half to what it is. And there's an index for inflation, so it creeps up a little bit each year. But by 2026, it'll probably be around a $14 million exemption and cut in half to about a $7 million or $7.5 million. So it's gonna be a significant change and going to impact a lot more clients.
And what's the likelihood of that happening?
Different people have different opinions. My opinion is, though, that it's pretty likely that that's going to happen. That's the laws that's on the books, and we've seen over the last several years that Congress can't get anything done anyway with
it'd take an act of Congress to stop it, right?
That's right. So with what's on the books right now, it's going to sunset in 2026, and that's my guess of what actually happens.
Yeah, and this year, Trevor's a critical year because a lot of what we're going to talk about here today is how do you lock in that exemption, kind of the strategy of use it before you lose it. And locking in that exemption, sometimes half of that planning needs to be done this year, and then half of that planning needs to be done next year. A lot of times you can't do this in 1 year, is that correct?
That's right. A lot of the planning that we do these days, we used to lock in exemption by gifting assets into irrevocable trusts that we create for our kids and grandkids. But with these exemptions being so high, we're asking clients to gift away $13.6 million worth of assets, and that's hard to do, and so we've changed our strategies where we have a client gift that much in assets to an irrevocable trust for the benefit of a spouse.
Yeah.
And so for a client that needs to utilize two of those exemptions, we want to have one spouse make a gift into a trust for the other, and then we want the other spouse to make a gift into a trust for the first spouse. But we need some time in between those two transfers, so we want to do something in 2024 and then potentially do something in 2025 and make those trusts a little bit different and different in time, and to avoid an IRS rule against doing that.
Yeah, and I hear you now talking about the word make a gift, and you refer to this exemption early on as an estate tax exemption. So the truth is this exemption could be used at death through your estate and be a reduction against the estate tax, but it also could be used during lifetime in a gift. So IRS really doesn't care when you use the exemption. You can use it while you're alive by making this gift or at death through the estate. And I think you've said it well, to use it during life, you have to make an irrevocable transfer. And we have to file a gift tax return, and we show the IRS, hey, here's a client that had an exemption of $14 million. They made an irrevocable transfer of $14 million over to what I'll call a green box or something that's free of estate taxes. And you file that gift tax return and you report that gift. That's the only way you can lock in exemption, right, is use it. It's not a matter of signing a piece of paper and say, hey, I'm agreeing to lock into my exemption. You have to make that irrevocable transfer.
That's right. And we love that term, the green box, right? I mentioned we generally make gifts into irrevocable trusts, and we call them, just to simplify the discussion, we call them a green box. And so we move these assets, we make a gift into a green box that protects assets from creditors and protects assets from this estate tax. And as clients do that, then they're able to have those assets. And when the spouse is a beneficiary of that green box, then they have indirect access to them. So even though they made a gift, they're still able to have some access to those assets through their spouse.
Yeah, and Trevor, it wasn't too long ago, in fact, I think it was around 2010, where the exemption that you could use during lifetime applied against lifetime gifts was only $1 million. It was capped. Even though the death exemption, in 2013 might have jumped up to around 6.5 to 7 million, the piece that you could use during lifetime was only $1 million. So back in those days, when people locked in exemption, they were only able to lock in 1 million. And back in those days, the typical traditional way of doing that was creating a green box for the kids and the grandkids and using that 1 million. Now, fast forward, now that exemption's 14 million, and IRS removed the restriction that you can use all of the 14 million during gift, or you can save it at death. And so tell us why then these, what we call the Spousal Lifetime Access Trust, or the SLAT, became popular.
Yeah, it's a good history lesson. And with that higher exemption, then that trust became so popular because we wanted to be able to make a gift, lock in that exemption, and still retain some sort of access to those assets.
Yeah.
And so by adding the spouse as a beneficiary of that green box, then we were able to have a client make a gift and still feel like they weren't giving up, all access to it, because if they, stayed married and were nice to their spouse, then the spouse might pull some out to buy groceries and to take them to dinner and things like that.
Well, and I think my estate plan's exactly that way. Half of my net worth is in a SLAT that I created for my wife, Nancy. And a year later, Nancy created a SLAT for me, and half of our assets are there. So now everything that we own is in a green box. We filed those gift tax returns. And now, no matter what those green boxes grow to, they're still going to be free of estate taxes, right?
That's right. Yeah, so we lock it in under the current high exemption amounts, and even if a client, is going to live another 20 or 30 years and that 13 million grows to 20 or 50 million, all of it's exempt from estate tax.
Yeah, and I think you said earlier, you can't do both of those trusts in the same year, because if I gave 13 million to Nancy and in the same year she gave 13 million to me, IRS would really say, under a reciprocal trust doctrine, I really created a trust for myself and she created a trust for herself, and it doesn't work.
That's right.
So thanks for explaining that, Trevor.
It's a good discussion.
I think it's a good idea.
A fun one for us nerds.
I have done it myself.
You've done it.
All right, thanks.